So the project itself, which this comes from, is our larger reparations project. And so part of the project we wanted to look at was the role of non-state armed groups and their contribution to reparations. And so we've been lucky enough during the past nearly 5 years of this project to get in contact with a range of people, some of whom we've interviewed and they'll be on the call today, but also others we've collaborated with, like Katharin and Ezekiel and others. So today, the format is going to go through pretty much the outline of the special issue as it'll probably roughly look. These are the confirmed articles. And so each of the speakers will be presenting today in some part, either in person, online via Zoom, or we've got some short videos from Peter and from Clara's team. And so we'll give about 10 minutes to each speaker, and then we will open it up to questions at the end after the Fighters for Peace have it's our conversation piece. And what's interesting about that, the final piece, is that was actually one of our first interviews with Fighters for Peace in Belfast. And so it's great having Christina join us again to talk through where things are at now. So today we'll give more space to the main substantive articles. I don't want to talk too much about the introduction. Our introduction pretty much sets out that, with non-state armed groups, we've had an area of interest which has grown in human rights law. It's always been an issue in humanitarian law the past few decades, but in human rights, how do we sort of deal with armed groups which control territory, and even situations where they don't? What are their obligations? We are often focused on when armed groups do commit violations, that it's an issue of prosecution, but often that leaves victims quite short. It doesn't really redress fully their harm. And so our analysis of reparations, and as we talk through these articles, covers a range of practices which is emerging. We can no longer say that armed groups don't do reparations, and we can't say that reparations themselves are dead letter law. These are very much dynamic and live issues around the world. So I think that's plenty of hearing from me. I'm now going to hand over to Katharin. Just a bit of notice, at about midday today, we've got our fire alarm being tested. So there will be a short alarm, hopefully, and no fire. So I'll hand over to Katharin now. But if you can save your questions to the end, that would be great.
Thanks so much, Luke. So I've been given 10 minutes, which is really quite short. More people coming in here. To talk about my article, which is called "The Procedural Right to a Remedy When the State Has Left the Building," and it's a reflection on armed groups, courts, and domestic law. So first of all, I just want to congratulate Kieran, Luke, and Cheryl for this special issue. I'm really looking forward to reading all the contributions, some of which are already online as advanced access and some of which aren't yet. My own isn't yet, but the final proofs are in. I think it will be available soon. So what I'd like to make this talk is a bit of a trailer for the article, just tell you like what it covers, some of the themes it covers, and encourage you to download it when it's out. So I chose to look at the procedural right to a remedy in my article. One of the reasons for that was that I was aware that quite a lot of work, very good work, has been done in recent years, focusing on the substantive right to a remedy, so on reparations, redress. And I thought that there was a bit of a gap there on the procedural right, so on access to a remedy by individuals and the procedures surrounding that. I decided to situate my article in times of armed conflict, so not post-armed conflict, again, because I thought that that was the moment in time when the procedural right to a remedy is perhaps most complicated, because at that point in time, armed groups are often rejecting domestic law of states and utilizing their own law and putting together their own courts. A thread running through the article is the current Al-Hassan case in front of the International Criminal Court, which is often analysed purely from an international criminal law perspective. I wanted to comment on this case because it's a very core kind of rebel governance case, perhaps one of the first rebel governance cases that the court's having to look at. The two armed groups in question in Timbuktu really did administer justice, and Mr. Al-Hassan was a police officer, and the crimes for which he's being prosecuted include war crimes and crimes against humanity, some of which were violent, but also some of which were sort of non-violent, his non-violent involvement in prosecutions and investigations and the court's role in settling civil disputes. So one might say that if armed groups do have an obligation to provide a remedy, that Timbuktu court was perhaps doing that. So in terms of my trailer, I'll just explain to you some of the points that my article kind of deals with. I first in the article review some of the rebel governance literature which has come out, also data sets which are now available on armed groups, domestic law and courts, providing facts and figures relating to the frequency with which armed groups are administering justice in territory under their control. And I also provide information regarding the extent to which civilian communities utilize these different mechanisms, some of which relate to common crimes, some of which relate to the resolution of civil disputes, and you know, accessing police forces. There's a lot of information there, and it's very important. So I set that out at the beginning of the article. I move on to kind of reflect on what I call the normative value of the procedural right to a remedy. And this really ties into this kind of age-old question of whether we should be talking about human rights law at all when it comes to armed groups. It's often been said, and is still said, that IHL does it all. International humanitarian law is sufficient. We don't need to be talking about human rights law. So I find it important to address that kind of head on and sketch out, you know, what the procedural right to a remedy involves: the obligation to investigate, the obligation to provide information in times when someone's been arbitrarily detained or disappeared, the obligation to prosecute. And I compare that to similar obligations in IHL, and I come to the conclusion that human rights law does add something extra here in terms of a victim-orientated perspective, in terms of an obligation upon the group. And it's therefore no surprise, I think, that when you review practice of human rights mechanisms or monitoring mechanisms, accountability mechanisms, addressing the behavior of states and armed groups, so the UN Special Procedures, the Syria Commission of Inquiry, UNAMA in Afghanistan, the Libya Commission of Inquiry, the Group of Experts in Yemen, we can find examples in which these monitoring mechanisms are reminding armed groups of their obligation to investigate, reminding armed groups of their obligation to prosecute, reminding armed groups of their obligation to provide an effective remedy. And they're doing so because this is a useful way or a legal channel to put pressure on armed groups to provide information, to investigate different kinds of crimes, ranging from crimes by armed group members to common crimes that have happened in the community. So I then move on in the article, and this is the bit I'm going to find hardest to summarize, I think. So this is the bit where I'm tempted to say, just read it, where I look at the main tools of the procedural right to a remedy, which I find are: 1, domestic law, and 2, domestic courts. And those of you who are familiar with this field will know that there have been quite a lot of really excellent studies lately on armed group law and armed group courts from a more kind of positive perspective, looking at the travaux préparatoires of the additional protocols, the Common Article 3 and the Rome Statute. And so I don't do that again, because I don't find that to be perhaps most necessary. Also, taking into account the fact that the journal is a journal for practitioners, I sort of figured that maybe a more interesting thing to do would be to take a higher altitude approach to this debate and really kind of engage with some of the controversies, asking questions that would perhaps point to why it is so controversial to suggest that armed groups should be, that human rights monitoring mechanisms should be engaging with armed groups' domestic law, and armed group courts. So in this part on domestic law, again, I review, I try and ask a number of questions, and here I think I really perhaps even stray away a little bit from domestic law and really engage with some of the controversies of the whole debate surrounding armed groups and human rights law and why it is so controversial, and the legitimacy dynamic that those of us who are familiar with this field are so familiar with as being this kind of dynamic that makes practitioners very worried about engaging with armed group law and engaging with armed group courts. And so I sort of provide some thoughts on this area, and I particularly find that to find answers, it can be helpful to ask ourselves, what is it that's special about armed group courts? Why are people getting so anxious about armed group courts, particularly when one considers how common plural justice systems are in many countries? So, you know, we've got lots of facts and figures on this of customary courts, different kinds of customary courts, where you have a very different discussion going on about engaging with this law and engaging with these courts. So I try and get to the bottom of this legitimacy dynamic and its role, where it comes from in the human rights law framework. Moving on to the courts aspect, I suppose I do the same. I stay at quite a policy level, engaging with the debate. One point that I note then is this idea that if armed groups do have an obligation to provide civilians with access to justice, this may provide some kind of clash with the Common Article 3 prohibition on the passing of sentences and carrying out of executions without the court being properly constituted. So I engage with this notion, well, can we really say that armed groups are under an obligation to do this if when they do this, their individuals risk being prosecuted, which might be what's happening then in the Al Hassan case. And I come to the conclusion that, you know, if an armed group really doesn't have the capacity to be running courts, then it doesn't make sense to say they're under an obligation to do so. I end the article by engaging with this developing Nexus debate, which those of you, again, who are familiar with this field will know is a bit of a thing, in that there's a disagreement, let's say, between some scholars, including myself, and the position that ICRC has taken on the Nexus, and whether trials and courts run by armed groups necessarily fall within the scope of IHL, or whether some criminal procedures run by armed groups might only fall under human rights law. And I indicate my arguments for why I think it's important to draw the Nexus parameter of IHL in a narrower fashion, so that there is some scope for the everyday kind of administration of justice to carry on without the risk of armed group members always being prosecuted, just as states can violate the right to fair trial without committing a war crime. I argued that I think it's important that armed group members should, in some circumstances, be able to be administering justice without international criminal law playing a role. So that's more or less my article, and I hope that was a trailer that will encourage people to take a look at it when it comes out. And I'll end there to give some time for questions.
Thank you, Katharin. We will now move to our first video session by Peter Dixon and Pamina Fairchild. Peter.
Hello, my name is Peter Dixon. I am a
too quick off the mark there. So Peter is one of our co-investigators on the project, but along with Pamina and others, he's been working on a project on everyday indicators in Colombia over the past number of years. And so this paper brings together the research from both projects. So I'll just start this video now. It's only a few minutes long.
Research scientist in the Conflict Resolution and Coexistence Master's Program in the Heller Policy School at Brandeis University in Massachusetts in the United States. Together with my co-author, Professor Pamina Fairchild, who teaches in the same program as I, we drafted this article based on an extensive field work we've been conducting with a pretty large team across a few different regions in Colombia. Currently, Colombia is implementing a historic peace accord signed by the government and the Revolutionary Armed Forces of Colombia, or FARC, in 2016. As part of this peace agreement, FARC ex-combatants have been laying down their arms and reincorporating into geographically defined villages, what are called ETCRs, alongside civilian communities. And for the most part, these are small rural villages and settlements where people share a collective sense of identity, which is informed as much by history, geography, and the environment as it is by the administrative borders of where they're living. These were actually originally envisaged in the peace agreement and its negotiations as temporary demobilization spaces, and were built mostly on borrowed land. But in fact, what has happened in practice is that some of these ETCRs have developed their own identities really as communities or villages in and of themselves. And in fact, 19 of the original 24 are currently transitioning to become permanent villages. With these FARC villages or FARC communities taking root alongside civilian villages throughout rural Colombia, it raises a significant puzzle for Colombia's path toward peace. And that is, what are the obstacles and the opportunities for coexistence between civilians and ex-combatant communities? That is, not between civilians and individual ex-combatants who are returning to civilian life, but civilian villages and their neighboring ex-combatant villages that are reincorporating as villages in and of themselves. We believe this puzzle in Colombia has broad relevance to a larger debate within transitional justice, and in particular to the nexus between transitional justice and DDR around the appropriate balance and the forms of individualized versus collective approaches to transitional justice. Now, both of these have their shortcomings. Individualized approaches such as individual reparations, individualized justice processes, or individualized DDR processes can be overly restrictive and not always that conducive to coexistence or eventually reconciliation. At the same time, collective processes such as collective reparations or administrative justice processes that are led by the state can be overly broad and ultimately do little to satisfy the justice-related concerns of individuals, and particularly of victims of armed conflict. We think the Colombia case of this community-based DDR offers intriguing lessons and potential middle ground to help balance individualized and collective approaches. What we call this in the paper is community-led collective justice, which we contrast to more traditional state-led collective justice. And we use the case of reparations specifically to do this, defining community-led reparations as reparations programs that are carried out by these FARC communities in lieu of the Colombian state directly for their civilian neighbors. Now, in the paper, we make this case for a community-led collective reparations process based on a rather unique database of what we call everyday indicators that Amina and I have been working to collect over the last couple of years. Here's an example of what those indicators look like from a global scale. We collected in the Department of Antioquia across 8 communities, which included 7 civilian communities and one of these FARC communities, or ETCRs, over 800 indicators of coexistence and justice that are relevant at the community level. We then coded these into these 6 higher level dimensions. And we just wanted to show this very briefly to illustrate the fact that these indicators, while coming from the ideas of coexistence and justice, represent a very broad range of daily experiences and a very holistic approach and definition of both of these ideas of coexistence and justice. And what we do in the paper is compare these indicators between the one FARC community where we worked and its civilian neighbors. And in particular, three key trends stand out, which we believe help build the case for this idea of community-led collective reparations. First, the indicators reflect the ETCR's, or the FARC community's, self-perception of itself as a community, not just as a temporary DDR processing zone as they were originally envisaged. The indicators speak to the ETCR building communal bonds within its own borders, as well as between itself and neighboring villages. And we believe a process of FARC communities carrying out reparative acts and projects for their neighbors, their civilian neighbors, would contribute to and align with these patterns. Second, the civilian communities where we conducted this work have, as would be expected, very complex perceptions and opinions of the FARC. But these are not only negative perceptions, they also include a number of positively framed indicators about former FARC members either receiving help or providing help in and around their communities. And notably, these include indicators related to ideas of the FARC supporting other communities in the context of providing them reparations or reparative justice. And again, we believe this model of FARC communities carrying out reparative acts for their neighbors would align well with these indicators. Third, and finally, these indicators show really remarkable alignment between these civilian communities and the single FARC community where we carried out this process, particularly around feelings of dissatisfaction, mistrust, and really alienation from the Colombian state. Both civilians and demobilized FARC feel that in these communities feel that the state has made promises and let them down and is not fulfilling the justice it owes them.
So at the end of Peter's talk, I had to, it was 14 minutes and he managed to get down to less than 10. So Peter's not on the call, so if you have any questions, I can pass them on to him directly. I'm delighted now to hand over to Dr. Ezekiel Jeffes from Geneva Call, whose paper is really interesting about the sort of practical aspects and is available on advanced article access on the Journal of Human Rights Practice at the moment. So I'll hand over to Ezekiel right now. Take it away.
Thank you very much, Luke. And well, first of all, thanks for putting together today's activity and also for putting together the special issue. I highly appreciate what you and your colleagues have done. I think this is quite an important topic. So just to go directly into the paper. The paper is entitled Responsible Rebels, Exploring Correlations Between Compliance and Reparations in Non-International Armed Conflicts. I should say that the piece was written in my personal capacity, although there are some examples related to the work of Geneva Call that are included therein. So as the title suggests, the idea of the paper was to see whether there are some correlations between the way armed groups behave and they position themselves with respect to international law, and how they also position themselves with respect to possible reparations. So in the last few years, there has been an increasing number of studies related to how armed groups operate in armed conflict, and different explanations have been put forward with respect to whether or how they respect international humanitarian law or not, and why this actually happens. So just to share some of these explanations that are included in the text, of course, we see that armed groups, for instance, they might be looking for some legitimacy at the international level, or they might be looking for some support at the domestic level. They might try to they might be supportive of certain rules of international law because they're supported by certain actors that are supportive of rules of international law. They might be trying to negotiate an agreement with another party in terms of a peace agreement or a ceasefire agreement. So demonstrating that they respect international humanitarian law, international law at large might be a tool for this negotiation. So there are different explanations that have been put forward as to why armed groups respect international humanitarian law. So the idea was to examine whether there is some correlations between this and the question on why armed groups actually repair for possible violations of the same rules during armed conflict. So having said that, the paper is divided in different sections. I mean, the first one deals with the international humanitarian law obligations that armed groups have. And then it goes directly into trying to understand these behavioral patterns that armed groups, how armed groups behave in armed conflict. And I think they're apart from the fact that there are all these various explanations as to why armed groups respect international humanitarian law, I think there are a few elements that are relevant for the discussion on reparations. And one of them is that armed groups are not static actors. They're dynamic entities that change their behaviors during armed conflict. And with respect to international humanitarian law, this is clear. An armed group such as the FARC, for instance, it was not the same FARC that was fighting in Colombia in the late 60s or in the 70s or in the 80s, and the one that was negotiating an agreement in the 2000 or was adopting certain measures before the conclusion of the peace agreement of 2016. And same can be applied to other armed groups and as well as other actors in general. I mean, they are dynamic entities that change their positioning with respect to international law during an armed conflict. So this is the first one. And the second conclusion that I think is relevant, trying to understand some of the behavioral patterns, is that armed groups, they don't have the same approach to every rule of international law. So they might be respectful of certain rules of international law. They might be not respectful of other rules of international law. Some rules might not be applicable because of a specific context. So the armed group does not position itself with respect to that specific rule. So bringing all these perspectives in mind, the question was, okay, let's try to understand how armed groups, why armed groups repair, at what time, and what are the factors that might influence this. And this is I would say the second half of the second part of the paper. So I suggest that some of the explanations that have been put forward with respect to the whole issue of compliance of international humanitarian law by armed groups can also be applied as to why armed groups repair. So for instance, if we're discussing about an armed group that is going through a peace negotiation or is trying to negotiate a peace agreement, it has been suggested that some examples can be presented that armed groups actually try to position themselves with respect to international humanitarian law because they use that as a tool of negotiation. So a similar explanation can be said with respect to reparations. They might be willing to apologize during a peace negotiation because they're in this, they're trying to gain some sort of legitimacy, they're trying to gain some support for that negotiation to take place. So it's the same type of explanation that can be used with respect to the respect of international humanitarian law. Same with respect to the relation with the local constituency. It has been said that armed groups may behave in a certain way because they might try to gain support from the local community, the local constituency. But a similar, and this has been said with respect to international humanitarian law, but little examination has been put forward as to in terms of reparation, and the same explanation can be used. Same with respect to, for instance, it has been said that there could be an issue of when discipline or some sort of armed groups at occasions they behave in a certain way because they want to differentiate themselves with respect to other groups, or they don't want to be perceived as a criminal organization or just as a mere criminal gang. So, for instance, an armed group that has taken the decision to punish one of its members because of a violation of international humanitarian law, that could be one way that the armed group can actually address this. So again, just some of these some of these examples I think can be used for reparations. And the last part of the paper, what it does is to bring some sort of practical perspectives of what armed groups have been doing. As Katharin just said, I mean, and Luke, they have said, it is now undisputed that armed groups repair for violations of international humanitarian law, and different ways of repairing have been used. I mean, of course, I think the traditional one would be would be apologizing and measures of satisfaction, but there have been other measures that have been put in place. So some of them, for instance, have been included in specific agreements with other relevant parties. It could be special agreements, it could be peace agreements, but also armed groups have, as I said, apologized through public statements and public declarations. So these are measures that have been commonly put forward by armed groups. Again, the question that was behind the paper is why this has actually been the case. And just to conclude, the last part of the piece addresses the deeds of commitment that Geneva Code has developed, and because some of them include certain measures that can be considered as measures of reparation. So armed groups, they sign these deeds of commitment that are thematic in nature. So we have 5: one on child protection, one on healthcare, protection of healthcare, one on the prohibition of gender discrimination and sexual violence, one on the prohibition of using landmines, and one on the prohibition of starvation. And what happens is that armed groups, when they commit to respect certain international rules that are included in those deeds, they also commit to disseminate the rules internally to their own forces, and also to prevent violations to take place, and if there are violations that may have happened, to take measures of investigation and to punish those measures, those actual violations. So, and armed groups have committed through this special agreement, deeds of commitment across the globe. So we have more than 60 groups that have signed one or more of these, and they have adopted measures that are restorative in nature, in line of what the deed asked them to do. So again, these are just practical examples that are reflected of some of the theories that I'm trying to put forward in a very brief and preliminary manner. But I think the goal was, again, try to understand why these measures have taken place. And also because I think this is, I mean, when we understand how armed groups operate, this is useful because these explanations can be used, for instance, when negotiating a peace agreement or negotiating with an armed group on the ground, as to why armed groups need to actually take restorative measures, take measures of reparation. So thank you very much for the time.
Thank you, Ezekiel. It's a really great paper, so it is, and I think it represents, like many other papers in the special issue, a really good mix of how law works in practice, and based on how law is understood and seen in armed conflict situations by armed groups, which are often outside the law. So I think it's a more dynamic take on how law works in practice, and particularly looking at the behavioural stuff around armed groups. And so you can check out the paper already in the advanced access. I really encourage you to do so, for those tuning in. Next, we are going to jump to Clara Hobeth and Michael's paper on the experience of the Special Jurisdiction for Peace. This paper is a really good take on how the alternative sanctions work with the FARC in Colombia before its sort of war crimes against humanity tribunal. Because it's still quite early in the morning in Colombia, they've sent through a short presentation, which I'll just share now.
Hi everyone, I'm Obed Martinez, and I will be presenting an article that Professors Clara Sandoval, my colleague Michael Cruz, and myself wrote as a contribution to this special number on non-state armed groups and reparation. Our article is located within the current transitional justice process in Colombia, and we are looking at how the former FARC combatants are going to contribute to reparations through special sanctions. Special sanctions are a form of punishment, which is different than the one practiced under ordinary circumstances. And it is different in the sense that it will consist of between 5 to 8 years of not imprisonment, but effective restriction of liberty. And it will consist also of a punishment that will be primarily directed towards repairing victims, the harm suffered by the victims, and repairing society and the larger communities. And so the practice, this sanction will put an emphasis on works and activities that those being punished will have to convey in the communities in order to repair victims and the communities and the social harm. So the emphasis is not put on the perpetrator and the harm on the perpetrator themselves, but on the harm suffered by the communities and by the society as a large. And we believe that these features might have an impact in practices of punishment and also in transitional justice. Firstly, we believe that these special sanctions may transform our contemporary practices of punishment because it is a living experiment of alternatives to prisons. So if this experiment goes well, as we hope so, the special sanctions will be opening up real alternatives to contemporary practices of punishment, which are basically grounded on prison. Secondly, we believe that this is a way to maximize victims' access to reparations through effectively engaging perpetrators in the process of repairing victims. And finally, we believe that by putting the stress on activities and works that the perpetrators have to convey in order to repair the communities, these special sanctions are also putting an emphasis and calling our attention towards different kind of harms that are experienced within conflict settings, as it is the case of social harm. And these were the couple of things that we want to draw your attention on as a way to invite you to read the article and to criticize it and enjoy it. Thank you very much.
So the article on HEP it ties in quite nicely, so it does, with the rest of the articles in the series, and touches upon what Ezekiel was speaking to there about the compliance and behaviors of armed groups. And what has been happening in Colombia with groups like the FARC is both innovative and also takes into account what Peter and Pamina are exploring about including communities, including those affected and victims, and how the law is practiced, and also how we get these armed actors to be involved in repairing the harm that's caused them. I'm now going to hand over to Cheryl and Kieran, who are going to present on our paper. I'll just share the screen as they come up.
Thank you, Luke. Hi, everyone. Hi, all our online colleagues. First of all, I should say it was a joy and a privilege to be involved in the special issue. It's kind of nice to be working with fellow nerds and nerd practitioners on a very specialist topic. And it was just lovely. You got a strong sense of community as we were kind of working through the papers and just reading the stuff and commenting. It was just a nice gig. It was a nice process to be involved in. So I was delighted. I think the other thing I should say is the broader project that Luke, Cheryl, Peter, and lots of Clara and others were involved in was also a joy. It was a huge monster of a project, as you'll hear a bit more about in a moment. It's to Luke's credit that it managed to get delivered, considering how ambitious it was. I think if we were sitting down to write that project now, we would probably scale back a little on our ambitions. So it was a big thing. But anyway, it was a joy. Both of those processes were a joy. So our paper in the special issue is called Changing the Script, Non-State Armed Groups, Restorative Justice and Reparations. In the paper, we explain what we were trying to do was to go beyond legalism, and I'm not trying to be negative about legalism here at all. A number of years back, I wrote a paper called Beyond Legalism, and essentially it was looking at finding routes to thicker forms of accountability other than just legal accountability. And in a reality where only a very small proportion of combatants or state actors involved in human rights abuses are ever held to account. I've always felt it's incumbent upon all of us to try to think more expansively about what accountability might look like. And so I think, as Luke may have said in the introduction, our broader project was an HRC funded research project. We carried out fieldwork in 6 sites: Colombia, Guatemala, Nepal, Northern Ireland, Peru, and Uganda. We did 29 interviews in that project with ex-combatants from a very diverse range of non-state armed groups, and 93 with victims of violence. Needless to say, in a data set that big, there's a huge plurality of perspectives in there. And in the paper, we're trying to do justice to that plurality. You know, people are not going to say that victims do not want the same things. In one site, we certainly, living and working here in Northern Ireland, see that every day. Victims want very different things. And I think we try to capture the plurality of that and not try to artificially conflate the views of others. The paper is heavily influenced as well by criminology, actually. I think a number of us over the years have been influenced by criminology. I used to teach and research in criminology, so did Cheryl. And there's a really interesting and rich criminology around the ways in which, and it's called desistance basically, but it's the ways in which people desist from criminal behavior, non-politically motivated behavior. And it's historically, that used to be a very crude discussion around rehabilitation, things being done to people. But the more clever and sophisticated versions of that now are really looking at how a person, a human being who has gone through a process, is not defined by their past experiences, but also what it takes to transform that behavior. So if, for example, the analogy being, if you've been involved in political violence, then you're in a process of conflict transformation. What does that look like? What are the structural aspects to it? And there's some clever criminology, basically, that we kind of pull upon in the paper. The paper relies heavily on restorative justice. Again, all of us have been heavily influenced by restorative justice. In part, that's because of the prominence of restorative justice here in Northern Ireland. So 24 years ago, myself and 3 others were involved in a dialogue with the IRA, attempting to supplant their system of community vigilantism, essentially punishment violence, as it was referred to, kneecappings, beatings, and so forth of alleged antisocial offenders. And so we were involved in a process of persuading the IRA, as part of the broader conflict transformation process, to end that behavior and to replace that informal style policing, some of the stuff that Katharin was talking about that armed groups get up to, with community-based restorative justice projects. They're very well known internationally and they're very highly prominent here. And we framed that as restorative justice. It didn't begin as a restorative justice intervention, but we framed it in part because restorative justice resonated with their value base. It made sense to them as people who saw themselves as political activists involved in a conflict on behalf of their community. And the same process arose amongst loyalist communities, certain loyalist communities. So restorative justice kind of made sense to us intellectually and practically because we'd had the practical experience of doing it here. But also when we started doing the data analysis, it resonated. It resonated with what people were telling us from the fieldwork. It resonated with efforts to move beyond a narrow retributivist view of justice. So it's a more expansive version of justice. It resonated with efforts designed to ensure that those who have been involved in human rights violations take responsibility for that, own the harms that they have committed, and try to do something to repair victims and communities that they have damaged. And as Cheryl will talk about in a second, it provided a theoretical and a practical route to the rehumanization of the other. Obviously, violence by definition requires a dehumanization process often. And so restorative justice, in the paper we argue, provides a route, a template by which the other can be rehumanized. And Cheryl will talk a bit more about that. Cheryl.
Okay, thank you very much, Kieran, and hi, everybody. So picking up where Kieran left off, using that model of restorative justice, we shaped the paper around 3 major conceptual themes around the capacity of reparations to meet victims' needs, the ability of reparations by non-state armed groups to perhaps contribute to the dehumanization, the destigmatization of former members of armed groups, but also the capacity of reparations to contribute to a more social or more community level restorative process and reintegration for former combatants. So to turn to the first of those 3 themes, we're thinking really about how reparations by non-state armed groups can possibly contribute to meeting victims' needs. And of course, as Kieran said, every one of us in this room has a very different need at any given time. And that, of course, is amplified by the experience of conflict and transition. And we were working across 6 different countries with multiple different communities within that. So this sort of 5-minute presentation, of course, is only the very broadest brushstrokes. But nevertheless, we were really starting from the assumption that is dominant in the transitional justice literature, that reparations can be a really obvious and a really visible way that a state can attempt to repair past harms suffered by victims. And we wanted to effectively flip that round. And using the influence of restorative justice, think about, well, how can reparations by non-state armed groups contribute to meeting victims' needs? And the 3 kind of bullet points on the screen there really talk about the capacity of reparations to do this in a more theoretical way. So whether that's taking responsibility for past actions, or whether it's sort of contributing to guarantees of non-repetition. But across the 6 different case study jurisdictions, we saw a number, or a multitude really, of different practical examples of how non-state armed groups can kind of offer some measure of repair to victims and survivors where they want that. And that might be, as the photograph on the screen suggests, contributing to demining projects. And that came across really clearly in our fieldwork in Colombia, where of course those who have the knowledge not only of where landmines are, but the knowledge of how to decommission those landmines has been able to be used and utilized in a really positive way, not only to make land safer for local communities, but also to make that land productive so that communities can, for example, farm on that land, or they can build on that land. We also saw, and as is very evident here in Northern Ireland, former combatants being able to engage in processes that have led to the recovery of the remains of people disappeared during periods of conflict. And often that is at the most kind of private and low-key efforts, but it has been hugely transformative for those individuals who suffered a enforced disappearance to be able to return that body and to be able to deal with that body in the way that they wish. But also we can think about ex-combatants making apologies to victims and survivors, or contributing to other forms of truth recovery. And often that's not, not talking about massive revelations, but it's about the small nuggets of information that can be really transformative to people who have had that experience of loss. And we can see that particularly on the screen here. I have a couple of quotes on the screen. The top one on the box on the left is from a victim. The one on the bottom left is from a former member of an armed group in Colombia. And of course, they're coming at this from very different perspectives. But as you read through the 2 quotations, the common theme is the ability and the need for truth recovery in the aftermath of conflict. And so just to read out a little bit of one of those quotes, we have a victim here saying, we would like to know who done it. We just want to know. I don't want convictions, but I would like to know who done it and why they did that. Then at the bottom, we have the absolute mirror image by a former member of the FARC. I'm talking about the really strong demand for truth and the importance of linking that to reparations. To know what happened, why it happened, and who is responsible. So people with completely polar opposite perspectives united by that common demand. And as we found out over the course of the fieldwork, the reality is that generally in times of conflict and transition, it's often only former members of armed groups that are actually able to deliver on these commitments. But also there's a lot of emphasis in the transitional justice literature on being victim-centered. And of course, that's a whole day's worth of interrogation itself. But if you think, and I'm probably thinking particularly of the context here in Northern Ireland, but state-led efforts at truth recovery can be very slow, they can be very piecemeal, very bureaucratic. They can often be caught up by political demands or political game playing. And actually it's this work by former combatants on the ground or at the grassroots level that actually in reality is not only doable, but actually might be more immediate and more effective than state-led efforts at transitional justice. But of course, the flip side to the capacity of reparations to contribute to meeting victims' needs is the capacity of reparations to humanize former combatants. And we look at that on 3 levels. And I think it's important to issue that caveat that that doesn't mean that we're advocating for like a whitewashing of the past or something like that. That's not the case. But again, returning to that restorative justice literature, obviously reparations can help meet the needs of those former combatants who we need to recognize the complexity of conflict. So whether that's the case of people who were victimized before they became involved in conflict, whether that victimization led to their involvement in conflict, but also those who were victimized as a result of their actions during periods of conflict. And you can see that so well in the example at the bottom of the screen. This was an interview in Bogota that we did with a Colombian civil society actor. And she was giving some experiences and some insight into the sort of work that she did. And she gave us this example of how young women often joined FARC. And on one level, there's a complexity there already that these are former combatants who are women who joined an armed group. But often, she said, those women joined an armed organization to escape the experience of victimization at home, and particularly, as she said, extreme violence and sexual abuse at home. So people who already had been experienced some of the worst forms of trauma, then joined an armed group, and then, as you can see in this quotation here, were victimized as a result of their involvement in that armed group. And of course, face considerable stigma and hostility to reintegration when they sought to return to their communities. So in sum, basically, reparations can help really bridge that gap between those different experiences of harm. But also, and I think this is where the influence of restorative justice particularly comes in. As Kieran was saying earlier, the involvement of former combatants in reparative acts, be that demining or truth recovery or building new schools or walls or restoring infrastructure, for example, can really put those individuals front and center in the process of conflict transformation. And that's not only symbolic, but it's also practical, because you are literally contributing to changing that script about what your past narrative was and what the future might look like. And in restorative justice terms, we're borrowing, of course, from our colleague Shad Maruna's work, and that's about that capacity of helping former offenders to make good. But also, and again, going into one of the biggest names in restorative justice, former combatants making good or making these efforts to kind of restore past harms can be a prime way to help them reintegrate back into their community, but also to do that in a more healthy and a more sustainable way. So we don't want people coming back into communities with like a mark of stigma over their heads. That's not going to promote reintegration or stable communities, and it's not going to promote ownership and conflict transformation. But if as you look at the quote at the bottom of the screen, as one of our interviews from M19 in Bogota said, if you see former members of FARC building roads or aqueducts or farming, it's not just for them, but that's a community project. It's with the people. And he said that has a really important capacity to break down people ghettos. And it contributes to lowering stigma, it breaks down prejudice and fear. And I think, this is a really important quote at the bottom of the screen. If you lay down your arms and you're in the community working, then you don't have to be afraid of those individuals anymore. So there's huge potential there of reparative acts to contribute to the rehumanization and the reintegration of former combatants. And so to hand over to Kieran again to talk about the community impact.
Sure, how are we doing for time? Look, 2 minutes to grant. I'll zip through this very quickly. Yeah, I mean, I suppose I was very influenced early on when I started working on restorative justice around a paper which talked about restorative justice and the risks of astructural bias. And the notion essentially was that if restorative justice is all about one party and another party doing nice cuddly mediation or something, what about the structure? What about the state? What about the structural underlying causes that create the social harms or violence or whatever in the first place? And so in the latter part of the paper, we talk a bit about this, about restorative justice as having a much more transformative vision, actually, about not simply seeing this as a way in which ex-combatants repair harms for individual victims, but actually about them making a bigger contribution to the transformation of relations and the transformation of the state itself, and not letting the state off the hook, in effect. That's what a critical understanding of restorative justice is about. I'll not take you through the quotes there, but basically in the fieldwork throughout, this kind of resonated around this transformative vision of restorative justice, seeing reparations as an expression of a transformation of relations and a transformation of structural causes of violence. For me as well, the thing that I like about this kind of work is that it's very practically orientated. So the demining example, in the Colombian context that Cheryl's mentioned, what you see there in practice is FARC ex-combatants working alongside the army and working alongside other people who used to be killing each other. And for me, that absolutely resonated with the Northern Ireland experience, where in the community-based restorative justice programs, they are led and staffed on the Republican side by former IRA activists who used to spend a lot of time trying to kill police officers and kill members of the British military. And those projects now, I can show you a picture actually of it. The man at the bottom here is Harry Maguire, former director of Community Restorative Justice Ireland, a very prominent former IRA activist, and that is the chief constable of the PSNI. And so we had, on those projects, we had cops, senior cops and former cops sitting on the board with people who, some of these people had met in the interrogation centers, with each other, i.e. people had been interrogated robustly, shall we say, by members of the RUC, the Royal Ulster Constabulary, and on the other side of the table, you had IRA ex-combatants who'd been involved in plotting and trying to kill police officers. And that's, for me, is that there's something about, this is not simply about transforming relations between victims and offenders. It's actually also about transforming relations between ex-combatants and the state and state representatives. And the way you do that with veterans of either state forces or ex-combatants is not cuddly stuff about let's just get on and find out what we have in common. It's practical expressions of work. It's demining. It's doing real bits of work. The community restorative justice programs in Northern Ireland, we're doing real bits of practical work, not let's just sit down and talk about our feelings. And so it's that practice orientated element of it that actually has the bigger transformation. Similarly, in the Irish context, the disappeared thing that Cheryl mentioned, what has happened in that context is that the IRA have engaged with this state structure that's created between the two governments, but that is run by an ex-British policeman, right? So the guy who runs it, is an ex-British policeman who has managed to persuade the IRA to give over the information where bodies are buried. It's a very highly secretive process, but our understanding of how it works in practice is that the only way is that people who are actually involved in the murders and certainly in the disposal of the remains are walking around forests and fields in rural parts of Ireland, because it's the only way you can't just describe where the body was. You have to go there. And so the levels of trust that are created between a former British policeman and former IRA people who have been directly involved in murders and the disposal of remains, that's transformative. That's a transformative expression of something called restorative justice. Okay, so we conclude the paper by again, health warning. Restorative justice and can be at times an overly ambitious expression and a way of seeing the world. And so in reality, reparations can only be delivered by ex-combatants if they're up for it, basically, and if they have capacity to deliver. And so we have that health warning. We are not engaged here in any kind of rejectionist discourses of other styles of transitional justice, including trials and accountability. What we are talking about in the paper basically are in some ways is seeing these as complementary to other sets. So it's not a rejectionist discourse about anything, but ex-combatants are the people, as Cheryl said, who can make the practical, and they're the ones who know where, literally in some instances, where the bodies are buried. They're the ones who, they have the truth that can be provided to victims. It provides a pathway to what we call in the paper moral agency. So it's not simply seeing reparations as something, or even DDR is the big critique of DDR is seeing it as something that's done to people, but actually seeing reparations as a way in which people can capture their own moral agency to address past harms. And that was a script we argued that needed to be changed. So that's good. Thank you all very much.
That's good. Thank you, Cheryl and Kieran. It's my great pleasure now to invite Christina Forsch from Fighters for Peace, who joined us from Lebanon. The piece we have, Fighters for Peace, grew out of an interview we had about 4 years ago, and has since sort of grown and changed and sort of developed based on like helpful feedback from the reviewers and the journal itself. So I'll hand over to Christina. I'll share the slides as well. Hopefully you'll be able to see those in a second.
Okay, hello, I hope you can hear me. Thank you, Luke, for introducing me and for inviting me to this event today. I'm sorry, I'm also quite far away, so I'm speaking to you from Lebanon. Yes, so Luke, if you can just give me a feedback if you can hear me, that would be great.
Yes, we can. Sorry, I just muted myself.
Okay, yes. Cool. All right. So yeah, thank you so much for these all these presentations, and especially the last one resonated very, very much with what we do. And it's probably a mix of things that were just mentioned, like some practical outcomes of restorative justice and some cuddly meetings between former fighters and victims. So we do both. Yeah, can you just go ahead, please, with the slides? So just very, very briefly to put you in the picture, the Lebanese civil war happened quite a while ago, from 1975 to 1990. It resulted in around 150,000 deaths. It's sick, so we don't have any definite numbers. For such a small country as Lebanon, there were around 3 million inhabitants in time of the war. So these number of deaths are quite high. And in the last presentation, it was already mentioned, it happened also in the Lebanese civil war, that people are around an estimate number of 17,400 people who are still missing. And it is not known if they are alive or in some prisons, for example, in Syria, or if they were killed. Next slide, please. So that's an open wound that has not closed yet. In post-war Lebanon, we, basically Lebanon's civil war came to an end by bringing the warlords on one table and by turning into political leaders. So this is something that helped to pacify the country, but it has become highly problematic because that was supposed to be a transitional solution, but this solution is still in place. And many of the key political leaders here in Lebanon nowadays are still those who were former warlords. In post-war Lebanon, there was a general amnesty for everyone who had participated in the war, which for the combatants, maybe for themselves, that was positive because they just, you know, return to normal life as if nothing happened. But in the overall perspective of general society, that was rather negative, because, especially for the victims, because there was no justice done. And this culture of impunity still prevails until today. So there have been, even recently, even 1 year ago, political assassinations, and no, you know, no justice was done to those victims or families. The only terms of reparations that happened in post-war Lebanon was that there were reparations done through different entities. One of
Sorry, I think we've lost Christina. Yeah, apologies. I think she's just dropped off the call. We'll give her a second to rejoin. In the meantime, if you have any questions, you can add them into the chat or the Q&A section. And we'll, about 5 minutes time, be taking your questions both from the audience here and online. We'll give Christina a second to rejoin. And here she's back. Hi, Christina. Sorry, you just dropped there. Go ahead.
Yeah, probably switch off my video. I don't know if that helps. So yeah, just to close up with this, there was no national reconciliation process and no national transitional justice process happening in post-war Lebanon for the last 30 years. So all of these things that in terms of reconciliation, in terms of transitional or restorative justice, happened on the level of civil society or on a grassroots level. So next slide, please. So yes, very briefly, who are we? Fighters for Peace. We are mainly a group of ex-combatants who got together because of many recurring cycles of violence, and we were afraid in those post-war years that Lebanon could easily plunge back into a new civil war. So that was our motivation, the motivation of our ex-combatants to come together and to send a message to the public, but also to the young generation to please not engage in further violence and please do not commit the same mistakes that we once had committed. What is special about our organization is that former enemies came together in this one organization. So when we talk about reparations in general, I don't want in this presentation differentiate between reparations, transitional justice, or restorative justice. When we just talk about reparations in terms of fixing humans, then we had quite a lot of work to do because we other former enemies, and it happened on this often individual level, but also on the level of the small community of ex-combatants who were willing to engage with each other, to talk to each other, and to come together to work for peace, for reconciliation, and for some sort of justice in Lebanese society. So we walked quite a long path of coming together and working together. Next. Okay, so I hope you can hear me again. So in terms of what did we do to address the harm that was committed by ex-combatants, is one of the things that we did is reaching out to war victims or to victims organizations, and I don't know. I wanted to mention something else before going there, and it was mentioned also in the last presentation, that actually as an ex-combatant, before you can engage in any kind of restorative or transitional justice process, you have to come to your own path. So you have to do a very thorough and deep process of critical self-reflection and inner transformation. And we worked a lot with our ex-combatants within our organization and supporting them in going through this process, which is a prerequisite for engaging in a more public way in any sort of reconciliation or restorative justice or peace building. So, so very much connected to the personal transformation of those combatants is the acknowledgement of responsibility for past wrongdoings. And of course, it is not enough if you do that in a very close community only. It is much better if you can do that in public. And we have had many, many events where our ex-combatants and those past wrongdoings in public. So that's very, very important, especially for the victims who suffered from the war and who suffered the biggest harm. But we have also achieved was to have joint appearances with victims' organizations, which also sends an important message and to future generations, meaning that former perpetrators and victims can come together, can sit together on one table and actually work towards the same goal. So for example, as Fighters for Peace, we have supported the legal agenda of victims' organizations. We have worked with the victims groups of those who were kidnapped and forcibly disappeared. And individual ex-combatants also gave information, valuable information to those victims, for example, about former detention centers, about potential location of mass graves, about centers where people were tortured, and whatever other important information that our ex-combatants could give to victims' organizations, they have done as much as possible for documentation purposes, but also hopefully still hoping for the closure of this chapter of those 17,400 people who disappeared. We hope that we can or could contribute to some findings that can provide closure to some of the families. And last but not least, also Fighters for Peace is against the general amnesty that happened for the fighters, for the combatants who participated in the Lebanese Civil War, because this general amnesty led to a culture of impunity till today. Next slide, please. And now we're coming to the more cuddly part. Let's say we believe that it is very, very important to engage with individuals, with communities, and to provide a safe space for dialogue, for acknowledgement of wrongdoing, for addressing harm that was committed, for engaging in storytelling from multiple perspectives, from perspectives of ex-combatants, as well as the perspectives of victims, their families, and the following generations. So we have done that using cultural tools, one of them being playback theater, where people from the audience share their stories, share their memories, share their grievances from both sides. In these events, people come together as human beings. There's no stigma, there's no preconceptions. It doesn't matter if you're an ex-combatant or a victim or the daughter or son of a victim. We are all equal human beings, and every person has the same right to tell his or her story. And through the artistic expression of the theater, it is possible to engage in this dialogue, in telling stories, in listening to each other, and in having all perspectives heard. And quite often these events have even led to some reconciliation between individuals, and has facilitated the healing of the wounds that exist in our society until today. So that has been an extremely important tool and way in addressing harm and in addressing grievances that exist in Lebanon on an individual and a collective level. And for us, these kind of tools have been very important to help prepare human relations. And right now we're engaging in a new theater project about accountability, with which we want to set a sign for ending this culture of impunity that exists in Lebanon until today. So next slide, please.
Christine, we're just a little bit short time, but we maybe move to questions.
Yeah. Okay, fine.
I mean,
yeah. Okay, so that was just another cultural tool, a photo exhibition, and that's connected also to public apologies. But yeah, I'm fine with closing off now. Yeah. Thank you. Thank you.
Thank you, Christina. It's really great to hear both, the perspective of the group and also the work it's really continuing to do and moving forward with. And ties in really nicely with the other papers, especially on the restorative justice. I'm now going to turn to our audience here online. If there are any questions, we've got about 10-15 minutes for questions or comments. If you are going to speak in the room, can you just turn on the mic so those online can hear us? So are there any questions? Yeah, Nikhil.
Hi, first of all, thanks for everyone for a really interesting presentations. One of the things that resonated for me and that I thought I'd ask is to Luke and Cheryl and Kieran, particularly with respect to the community-based restorative justice work that you guys were discussing and the case studies that you had explored. Luke and Cheryl probably can surmise why what interests me about it. One question I had was, one of my PhD research is looking at guarantees of non-recurrence and measures in Sri Lanka as a case study at what both state-led, but also particularly non-state grassroots community-based initiatives towards non-repetition, reconciliation, restorative justice, steps that they have taken when faced with a fairly non-compliant state. And, you know, as we see in recent developments going backwards, in fact. So I was just curious to hear, in terms of those case studies, did you see any sort of distinction in the victims' responses or the individual's responses in your interviews in situations where they're distinguished from a situation where there's, like, as in Sri Lanka, and like an outright military victory versus situations where there's a negotiated peace where both sides of the conflict, ex-combatants, are essentially walking away from the conflict in some, obviously not in lockstep, but there's a negotiated peace versus in a situation where, in Sri Lanka, for instance, I guess what I'm thinking of is in Sri Lanka, for instance, where there's been such a clear outright military victory, the prospect for victims to be, individuals to be sort of satisfied with, there is a certain outcry for some form of justice, and in a more criminal sense. That's not to suggest, as you've said, that it can't be in complementarity with restorative justice measures, and those are all ongoing. But I was just curious to see if that distinction came up in some of the cases that you guys had reviewed.
I can talk in the Northern Ireland one, if you guys want to come in on some of the international. So that's a good question. In the Northern Ireland context, a lot of the heavy lifting in terms of non-recurrence has actually been carried by ex-combatants. So in a context where at different stages in the last 20 years of a peace process, you've had, for example, dissident Republican organizations, mainstream Republicans, former IRA combatants, have been at the core of trying to minimize the capacity of spoilers to undermine the peace process. So, for example, the primary target for a lot of those dissident Republican groups has been to undermine the Sinn Féin project, essentially, to undermine the direction that Gerry Adams, Martin McGuinness took the Republican movement. At a community level, the people who have done most to challenge the actions and activities of spoiler groups who are attempting to push this society back to conflict have been ex-combatants, really taking significant risks. I mean, so for example, the Community Restorative Justice project that I'm affiliated with has been attacked a number of times. There was a bomb placed outside our office by a dissident Republican grouping. A number of senior staff have had death threats, credible death threats. Now, they haven't gone as far as to attempt to assassinate any of the ex-IRA ex-combatants, but they've taken on a leadership function in embedding the peace process, and that's in a context where, number one, you've had spoiler groups within their own community, but secondly, at different stages in the peace process, including currently, you have had a British state with a very cavalier approach to the peace process, essentially. So under Boris Johnson's government, you know, they have rolled back on significant commitments that were made as part of the peace process, particularly around issues around legacy, for example. So you will have, Boris Johnson, for example, has been pressing for an unconditional general amnesty, primarily designed to be addressed to British Army veterans, but it would have had the consequence of applying also to ex-IRA combatants. Ex-IRA combatants have been taking a lead in their own communities against a general amnesty, a bit like the Fighters for Peace position. So again, where you would expect people within their own constituency saying, hold on a minute, I would quite like a general amnesty, thanks very much. I'm in my 60s now and I don't want to be arrested for stuff I did during the conflict. They have taken a principled position, particularly Republican ex-combatants, aligning themselves with victims in opposition to state cavalierness and towards the peace process. So not only managing non-recurrence within their own community in terms of managing spoilers, but also managing an obdurate state. Now, it's nothing like Sri Lanka, but still Boris Johnson's approach to the peace process here has been nothing short of criminally negligent, and we think about Brexit and everything else. And yet they are the people managing their own constituencies, and in some contexts doing that in partnership with victims organizations. So it's a very interesting space where we talked about moral agency in the paper, where actually ex-combatants are exercising a moral agency within their own communities and in the face of an obdurate state. It's quite a significant contribution they've made in the Northern Ireland context.
Yeah, I think talking about dollar context, we've looked at Nepal, which you're very familiar with, and also like Guatemala, where you did have a sort of the former rebel groups becoming then political parties and being involved to some extent in governance. I suppose maybe an example which sort of maybe sits outside these is Uganda. We had former commanders of the LRA who benefited from the amnesty, then helping the Ugandan army track down and hunt other members of the LRA. But it's very complex, because then you've got a lot of the former abductees and other fighters who have returned home and haven't been so much involved in broader debates and reparations, but have been involved in sort of the matter would put the sort of traditional processes where they're ran. I think what has been interesting in coming out of Uganda has been the role of the Women's Advocacy Network. So former wives of commanders seeking for recognition of their children born of those commanders out of rape and sexual slavery, to get recognition for their children to have rights within Uganda, because it wasn't provided by the state. And in that way, it's sort of guaranteeing that those children aren't left outside of the law, so they can own bank accounts and go to university. But in Guatemala, talking to one of the commanders of one of the main armed groups, comparing to what was happening with FARC, they said, at the time in 95, when the peace accords were signed, we weren't thinking about reparations. It wasn't on the agenda. It was more about peace and reintegration. So we're seeing a sort of shift in how we understand. I think, definitely Colombia's sort of changing that. It'll be interesting to see what happens if, a sort of negotiation happens with the ELN in Colombia, or even the Houthis in Yemen, where that moves forward in terms of guarantees on repetition and the involvement of armed groups. We've got a few more minutes left. Is there any other questions? Sorry, Christoph, yes, sorry, go ahead.
Yeah, thank you. Very exciting project. Also, already look forward to reading the special issue. I have two questions that also relate somewhat to the context or the conditions that make these reparative actions by non-state actors either possible or more effective. The first is, how does this relate to the overall transitional justice context? Maybe you can say something about, like, from your case studies or the case studies from the special issue, in terms of like what happens when we have prosecutions going on at the same time. Do then, if ex-combatants step forward and acknowledge crimes, this can prevent, or what is when amnesties are in place, makes something like this more possible? Like, I'm just wondering about the overall conditions on this side. And the second question is, there are contexts where non-state actors either become the government or are integrated in the government. So how does that affect the dynamics when former ex-combatants actually are in state functions and then want to assume responsibility for crimes that they committed as ex-combatants and engage in these kind of reparative measures? How does it change the dynamics? I don't know if you have examples.
Yeah, no, thanks, Christoph. Just maybe because we're going to go a few minutes left, I may draw on Beatrice, if you want to maybe also ask your question.
Hi, thank you very much. It was a super interesting presentations of everyone, and I'm also really looking forward to read all the articles. So yeah, because of the time, very quickly, I was just wondering, well, I don't know if Peter Dixon is there or not, but if also people can discuss a bit more. It was really interesting to hear about the FARC communities and their relation with civilian communities. And indeed, in restorative justice is always mentioned, how can we reintegrate the offender within communities? And I think the question here opens up with community and how to do it, right? Because also FARC members committed crimes in different parts of the region. So which communities? And in this sense, I just wanted a bit of more, if it could be developed, the advantages or disadvantages that have been seen regarding only FARC communities. And one of the tensions, maybe the potential tensions, is civilian communities and mainly victims seeing that they are receiving more either resources or money to create their communities, but they have been left aside. So if he can discuss, or someone else, a bit more regarding these tensions and advantages of only FARC communities and then the relationship with civilian communities. Thanks a lot.
Yeah, thanks, Beatrice. There's no other questions in the room. I think, does anybody want to answer the questions? Go ahead, thanks. I think with Christoph, your questions about the impact of the first part of the transitional justice impact of all these other measures, I think, you know, the threat of prosecution or other truth measures, there's a risk of getting the backs up of ex-combatants. You know, they say they maybe try to game what the benefit will be for them engaging this year, and also then how it exposes them in making reparations to victims. So I think, and Kieran can speak to the direct in relation to the Northern Ireland context, is how to sort of coordinate and even sort of think about how different, I don't want to say sequencing, but you know, how legal protections can be built in so people can do certain things. So with the Disappear Commission, information is given privately, and it's on the basis that it can't be used in any sort of, you know, civil or criminal prosecutions. But if evidence outside that emerges, it can be. With your second point, it was on what? Sorry, I can't remember.
When essentially former non-state actors, combatants, move into government, because this very often happens after like a peace resolution or something, and then take over like government functions.
Yeah, I think Nepal's a good example of that. We had the Maoists move in, and you know, during part of the conflict, they were advocating for like getting rid of the caste system. They were advocating for like those in rural areas who've been affected and disappeared by state actors, and yet when they got into power, certain reparations or the interim relief program was brought in for, you know, landowners and for those disappeared, but it also excluded a lot of other victims. And there's an example of the Madi bus bombing, where you have governments and ministers, former Maoists, using their power to threaten victims if they don't accept compensation, and sort of like victims trying to push against the amnesty and push for prosecution. So I think there is, you know, hegemony there. When actors do get into power, they don't necessarily act better than the state who did before them. I think with the other context, which we looked at very briefly, was South Sudan, and how there you have the former armed group forming a new country, and yet people breaking off, you know, the vice president breaking off, and sort of conflict effect in that group. There you have former fighters, former comrades, excluding those who broke away, and not seeing them as victims, even though they've lost their homes, been tortured, they've been killed. So I think we're talking about, and that what Kieran said, is about the will of these armed groups to already engage with this, but it's also to recognize, and you know what Christina was talking about, to sort of internalize and to think about and reflect about what they've done was perhaps wrong. So it's quite complex. Beatrice, I think Peter would be best answering those questions, because he's got really good insights on those sort of relations between civilian communities and FARC. I can email you later with his email, and I'd be happy to chat with you. But it is something that's quite fragile, especially because it's mostly in rural areas. Kieran, do you maybe want to jump in?
Just on Crystal's really interesting point, the second point about ex-combatants going into state structures. And it's not from this particular project, but from other bits of research I've been involved in. The evidence is that sometimes they're not the best. Actually, you know, they can create quite an obstructionist role, and once they come into state structures. I've done a lot of work in South Africa over the years, and certainly once the ANC comes into power, they have quite an obstructionist role for the outworking of transitional justice. So, for example, I'm thinking about the delivery of the reparations programs in South Africa after the TRC. And it's clear there was a lack of political will to actually deliver on what was promised. Similarly, in terms of the Truth and Reconciliation Commission itself, what was sold in South Africa to the victims of apartheid was, look, here's a moment where we have this national reconciliation project, and those who benefited from the apartheid regime have an opportunity to come forward, tell the truth about what happened, and they will get an amnesty. But after that, if they don't do that, we will be in power, and we will deploy the power of the state in order to hold them to account. What happened, as we know in reality, and in some instances was led by ex-combatants, was that not only did they not properly resource the National Prosecution Authority in South Africa to do exactly that, to prosecute the beneficiaries of apartheid who'd been involved in human rights violations, but there was actual political interference in the National Prosecution Authority by ex-combatants in order to prevent prosecutions of those involved in apartheid era abuses, well, they sold it as part of the national kind of reconciliation project, but actually in part, it was because ex-combatants themselves on the Liberation Forces side were concerned that if the principle was established that you're going after prosecutions for state actors, they'll be coming after us too, because we were also involved in human rights violations. So actually ex-combatants in that context played a very obstructionist role in the delivery of transitional justice. I have a PhD student who did her PhD on Kosovo. The KLA in government, once they came into government, did exactly the same thing. They tried to prevent, even though they made promises, as Luke said there in terms of the Maoists and Nepalese, they made promises when they were an oppositional force, but actually when they get into the state structures, they can become very, very obstructionist and suddenly lose the moral vision that guided them during the struggle. So it's really interesting that what happens to armed groups once they get into state structures. Absolutely.
I think we'll draw things to a close because we're a little bit over time. Thank you everyone for attending today. Thank you particularly to our contributors to the special issue. It's been a long journey, but it's we're hopefully at the end of it. We'd also like to thank the Journal of Human Rights Practice, the editors, the reviewers, and also Ryan Griffiths, who's been a great help in sort of steering things along. Some of the papers are available on advanced access. Some of them will be joining in the next week or so. We will load up this video and do a proper share of all the papers in the coming weeks when it's all finalized. But thank you again for joining us today. And I hope you read the papers because they're really great. And it's a really exciting area to see this strong contribution from leading people in the field add to. So thank you.
Anybody's got an interest, if anybody wants a copy of it and can't see it online in the spirit of guerrilla publishing, just email any of us and we will send you a fucking PDF, because I am sick of publishers ripping academics off. So anybody wants to read it, any of the papers, just email any of us as the editors and we'll make sure you get a PDF of it.
Yeah, so that's Kieran McEvoy saying that, so you can email him. So I'll stop recording. So thank you everybody for joining us online, and thank you Christina and Ezekiel for speaking online. Good seeing you. All the best.
Thanks everyone.
Thanks.
Thank you very much. Bye-bye.